All right, sir, can you tell me your name there at Department of Corrections?
Reynold Francis Brown.
All right, we'll go on the record in people versus.
Sir, can you tell me your name there at Department of Corrections?
Reynold Francis Brown. Okay, we're on the record in People versus Brown, case number 244898. The record should reflect that Mr. Brown is present today by video from Department of Corrections. Yeah.
Thomas Seeger appearing with and on behalf of Mr. Brown.
Thank you, Mr. Seeger. Can you tell me how we want to proceed in this case?
Your Honor, there is a resolution wherein there would be an added count 6 of attempted felonious assault, which would make it a 2-year felony. Additionally, Your Honor, there is a sentencing agreement wherein they plead to this but not exceed the current sentence for which he's under. Additionally, Your Honor, albeit I don't know if it will be relevant or not, Your Honor, there is a double jeopardy component to this because he had pled guilty in another county to fleeing and eluding. And so for purposes of scoring, it would be my position that the fleeing and eluding can't be contemplated in the guidelines because they're not something that could result in a conviction, at least here. They may have otherwhere. So I'll have to get the report and then I'll have to determine whether or not there are any objections to the scoring as it's stated.
Okay. What is Mr. Brown's current sentence?
Your Honor, I believe they were there for 2 years, I think. Is that what you told me, Mr. Brown?
3.
3 years, yeah.
Okay, so the sentence in this case the agreement is it would run concurrent and not exceed that 36 months.
Correct, yeah.
So which wouldn't lengthen his earliest out date.
Correct, yeah.
Okay. Mr. Ziegler?
Other than the issue regarding the scoring, Your Honor, it's a fair statement of the plea agreement.
Okay. All right, so regardless of how the scoring turns out, there's an agreement as to the maximum sentence, right? So
Correct.
That's more or less kind of a non-issue. I mean, it needs to be scored correctly and I'll have to make that determination, but.
True, yeah.
Okay.
And given that it's a 2-year max, Your Honor, it can't possibly exceed.
True.
So
Good point. Okay. All right, Mr. Brown, were you able to hear all of that?
Yes, Your Honor.
Okay, and is that how you want to proceed today?
Yes, I would very like that.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can lower your hand. And are there any other collateral consequences to this plea, Mr. Seeger, that you're aware of?
No, Your Honor.
Okay, so Mr. Brown, you understand that by pleading guilty to this added count of attempted felonious assault, that the maximum possible penalty that you could face would be up to 2 years?
Yes, Your Honor.
With that penalty in mind, what is your plea to that charge today?
Guilty.
So right now you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes, I do.
And you understand that you're giving up and waiving all of those rights by pleading guilty?
Yes, Your Honor.
Also, you don't have any automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. Do you understand that?
Yes, I do.
Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything other than what we said here on the record today?
No, Your Honor.
Is it your own free choice to enter this plea?
Yes, it is.
And are you pleading guilty to this crime because you are in fact guilty?
I am.
So this happened back on June 25th of 2023. Is that the correct date?
Yes, Your Honor.
On that day, were you here in Kalkaska County?
Yes, Your Honor.
All right, and were you involved in an incident with police on that day?
I was.
And as part of that incident, were you operating a motor vehicle?
Yes.
And at some point, did you attempt to hit one of the deputies with your vehicle in some way?
Yes, to elude the police, Your Honor. Yes.
Okay, all right. Mr. Ziegler, are you satisfied with the factual basis?
I am, Your Honor.
Mr. Seeger?
Yes, sir.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Seeger?
No, sir.
Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Seeger?
Yes, sir.
Right, Mr. Brown, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. And we'll set this matter for a sentencing hearing. Mr. Brown, you do have the right to have that hearing in person. And if you wanted to exercise that right, I would sign an order to have you transported here to Kalkaska County for that sentencing hearing. You can also waive that right and we can have that hearing by Zoom like we're doing today. Do you know how you'd like to proceed on that?
Zoom would be sufficient to save on the court's time and money.
Okay, so the court record will reflect that Mr. Brown has waived his right to in-person hearing. And so Mr. Ziegler, if you could prepare a Zoom writ for Mr. Brown. Mr. Brown, do you have any questions at all?
No, Your Honor.
Mr. Seeger, Mr. Ziegler, anything further on this case?
No, Your Honor.
Your Honor, ordinarily would not mail a PSI to the Department of Corrections, primarily. Well, the rule continuously changes, but in any event, Your Honor, in this limited situation, unless there's an objection, I'm going to mail him a copy of the pre-sentence report so that he can review it, because it's not always easy to have dialogue with the Department of Corrections.
Mr. Ziegler, any questions?
I have no objection.
All right, so Mr. Brown, Mr. Seeger is going to get you that pre-sentence report so that you can have a chance to review that before the sentencing hearing, okay?
All right, I appreciate that.
Is there a different PAC code for that ad account, or is it just an A?
It should be count 4, PAC code with an A in brackets.
Great, thank you.
Okay, Mr. Brown, we're going to go ahead and disconnect. Thank you.
Thank you, Your Honor.
People versus Ford Smith, case number 244896.
And Your Honor, he's in the Wexford jail.
Oh.
Unless they brought him here. On the docket, it says via Zoom.
Don't see Wexford connected yet.
Mr. Alexon is here, Your Honor. Additionally, Your Honor, it's not really an add-on, but the Mooneyham matter had come down. Mr. Kylander's sentencing, I had sent an email to Jennifer asking her if we could change the time because he has a doctor's appointment with his doctor. He does have cancer, so he's trying to get to it depending on what you do with his sentencing.
Yeah, as long as there's no objection for Mr. Ziegler, I'd be happy to take that case anytime.
Thank you, Your Honor. I think he's in the lobby, but Mr. Alexon is here and Mr. Kylander texted me and he said he's in the waiting room.
Okay, Mr. Alexon, if you want to come forward. We're on the record in People versus William Alexon, case number 224708. Mr. Alexon's present here in the courtroom today. If I could have counsel take your signatures on.
Ryan Ziegler, yeah.
I'm Steve Graham with on behalf of Mr. Alexon.
William Alexon, defendant.
Thank you. This is set for a probation violation hearing today. Mr. Seeger, how do we want to proceed?
Your Honor, it's my understanding that Mr. Alexon would admit the violation as much as he violated criminal law.
Mr. Alexon, is that correct?
Yes, Your Honor.
All right, so is there, because I've got one technical and three non-technicals.
I think that was the sum and substance of these based, and, Ms. Wagner, do you want him to admit to anything else, or is that sufficient?
No, I believe he was gonna plead guilty to one technical, the possession of the meth, with the other counts to be dismissed. I might have put that a typo wrong in the email. And the counts would be dismissed, and then I would be recommending that he be unsuccessfully discharged from probation, and Barrett has the paperwork to present to the court for that matter.
Okay, so Ms. Wagner, you're not asking for any additional jail time?
I am not. It appears that, Your Honor, he's probably going to be facing some consequences in Crawford County.
Okay. All right, so Mr. Alexon, is that how you want to proceed today?
Yes, Your Honor.
Okay, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. Mr. Alexon, you understand that you have the right to have a hearing as to whether or not you violated your probation?
Yes, Your Honor.
And you understand that by pleading guilty today, you're going to be waiving that right?
Yes, Your Honor.
And in light of that, did you still want to plead guilty?
Yes, Your Honor.
Has anybody threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anybody promised you anything other than what we said here today on the record?
No, sir.
Is it your own free choice to plead guilty?
Yes, sir.
Are you pleading guilty because you did violate your probation?
Yes, sir.
So back in May of 2023, so almost a year ago, were you on probation here in Kalkaska County?
Yes, Your Honor.
And were you aware that one of the conditions of your probation was that you were to not be in possession of any controlled substances unless they were prescribed to you?
Yes, Your Honor.
And did you violate your probation by being in possession of methamphetamine?
Yes, Your Honor.
Did you have any kind of prescription or other legal right to have that?
No, Your Honor.
The court finds that your plea is knowing, voluntary, and accurate. The court is satisfied based on your testimony that there is a factual basis to support a finding that you did violate your probation. The court will accept the guilty plea. In light of the recommendation, Mr. Seeger, is there any objections to proceeding with sentencing right now?
No, sir.
Mr. Ziegler or Ms. Wagner, other than what you've already indicated, is there anything else that you wanted to say regarding sentencing in this case?
No, Your Honor.
I do not, Your Honor. Thank you.
And Ms. Wagner, just again, you're just recommending unsuccessful discharge and preserving any outstanding fines or costs?
Yes, Your Honor. I can look. He might be paid in full. I'm not for sure. I could look real quick though, but if he owes, I'm expecting him to pay.
Okay. All right, Mr. Seeger or Mr. Alexon, anything that you wanted to say?
Your Honor, I would just ask the court to follow the recommendation, and I'm not sure if you recall or not, Your Honor, but he has already pled Crawford County and accepted the sentencing. It's May 20th. And so in any event, Your Honor, at some point in time, once you receive the pre-sentence report, if there's any actions, I should consider.
I think Mr. Alexon, anything you wanted to say?
No, Your Honor.
Okay, so, and I am of course aware of your other matters in Crawford County. I think given the circumstances here, the recommendation is appropriate and the court's going to follow that. So the court will discharge you from your probation in this case unsuccessfully. To the extent that there are any outstanding fines and costs, the court will preserve those. You do have the ability to seek an appeal of the sentence. If you wanted to do that, then you would need to file that paperwork within the next 42 days. And that's, if you have further questions, Mr. Seeger could answer those. But otherwise, the court will sign the order for your discharge in this case today. Ms. Wagner, anything further that we need to address for the record?
No, Your Honor. Thank you.
Okay, thank you, Mr. Alexon. That's all for today.
Thank you, Your Honor.
People versus Kylander, case number 244883. And the record should reflect Mr. Kylander is present here in court today. I guess counsel put your
Thomas Seeger, praying with an on behalf of Mr. Kylander.
This is the date and time set for sentencing in this matter. And Mr. Kylander, did you have a chance to go through the pre-sentence report and speak to Mr. Seeger about that?
I did.
Okay. And Mr. Seeger, are there any additions, deletions, or corrections?
No, Your Honor.
Mr. Ziegler, did the people have any additions, deletions, or corrections?
No, Your Honor.
Anything on behalf of the people for allocation?
Your Honor, I've had an opportunity to review the report. I think the recommendations are appropriate. It's particularly noteworthy to me that the entirety of the defendant's history, including this matter, largely relates to substance abuse, particularly alcohol. I note that he's previously completed the sobriety court program. It sounds like he had a relapse, and that was primarily the cause of this issue. I'm hopeful that the term of probation can help him get back on track and address that issue. So I think the recommendations are appropriate. I'd ask the court to adopt.
Thank you. Mr. Seeger?
And Your Honor, I don't generally have any objections to the way that it's stylized. The probation department had asked for a relatively short period of probation. The only question I had is that I'm not entirely sure what action they're able to correct during the course of probation. Clearly, you shouldn't be drinking. Clearly, he has the mechanisms and knowledge not to use alcohol, or at least should realize that it only causes some problems. And it is concerning that there was a firearm involved in this particular case. But be that as it may, Your Honor, I'm not entirely convinced that probation is required. I'm not saying that it would be unfounded if the court thought that it was a good idea to allow him to have that mechanism. However, additionally, Your Honor, because he has cancer, he's going back and forth with a lot of different medical appointments. I'm concerned that there'll be some kind of defect in his probation somewhere in time. But be that as it may, Your Honor, if the court sees it that to give him probation in whatever period of time it needs to be just reasonable, he accepts that. He recognizes what he did on that day was appropriate. Although it certainly should be handling a firearm or influence of alcohol, no matter the reasoning. So in any event, Your Honor, I would just ask the court to maybe consider not imposing any probation, just limit to cost and fines. But again, if he doesn't have any particular objection, the court thinks that probation is appropriate.
All right, thank you, Mr. Kylander. Anything you wanted to say?
No, as Mr. Ziegler said, I did wrong. My actions were totally wrong. I failed to comply with the lawful order. That is on me. I'm really scared for my life right now for the next 6 months down the road, what I got to go through with the oncologist and the doctors. And I will comply. If we do get a little bit of probation, I will comply and do what I need to do with the courts as well.
All right, I read through the report. Obviously, Mr. Kylander, we know each other. You spent a couple years having meetings every week through the sobriety court program, so I'm well familiar with you and your background. And you've obviously demonstrated that you're able to maintain sobriety over a sustained period of time. And I hope that this was a momentary relapse. But I think some probation here is appropriate to monitor that over the next period of time to make sure that you're back on the right track. And that's the primary focus for me in terms of the probation is to monitor to make sure that you're staying sober, because this was a really dangerous situation. And when you introduce firearms, one wrong move with a firearm in the presence of police can get you shot or killed, because they've got to be thinking about their safety and they have no idea what your state of mind is, what you may or may not do. So that's concerning to me, and I don't want to have a repeat of this because of a relapse. So I think some probation again to monitor alcohol use specifically is appropriate here. I think that our probation agents are very reasonable. I don't think anybody's going to question the legitimacy of your health concerns, and I'm sure that they will work with you during probation to accommodate the treatment that you need, while still providing the oversight that I think is appropriate given this incident. I don't think additional jail is appropriate here given the circumstances as a whole, so the court is not going to impose any additional jail. The court is going to place you on probation for a period of 6 months pursuant to all the conditions listed in the report. The court is going to order that you serve 2 days in the Kalkaska County Jail with credit for 2 days served. A crime victims assessment of $75, a supervision fee of $30 per month while you're on probation. attorney fees of $350, $53 state cost, $325 court cost, and a $100 fine. Because this is a misdemeanor, you do not have any written appellate rights, so you're not going to get a piece of paper that explains to you what your appellate rights are. However, if you wish to appeal this sentence, you would need to file for that appeal within the next 21 days. If you have more questions about that, Mr. C.
I don't, just like what I told you, I was in the wrong. I was in the wrong and it shouldn't have happened.
Ms. Wagner, do you want are you going to be the supervising agent on this?
Yes, he can come on over and I'll give him recording instructions.
Okay. Do you have time to do that before you need to go? Okay, so if you can just stop and see Ms. Wagner this morning,
Okay,
and good luck to you going forward.
okay, will I have any jail time in the next couple of days, or the 2 days served is what was,
That's it.
that's it,
Yeah.
okay. So, okay. Thank you, Your Honor.
We did have Wexford for a minute there, but they disconnected. And Ms. Barney's also in Wexford, is that correct?
Yes, Your Honor.
All right, let's take a short recess and we'll come back on the record as soon as we- All right, there at Wexford, can you tell me your name, please?
It's Mr. Smith, Your Honor.
Mr. Smith, are you able to hear me?
Yes, Your Honor, very well.
Okay, great, thank you. All right, we're on the record in Ford Smith, case number 2, People versus Ford Smith, case number 244896. Record should reflect Mr. Smith is present by video from Wexford County. Mr. Seeger, how did we want to proceed in this?
Your Honor, I just filed after talking to Mr. Smith again, the motion, and the motion is somewhat dispositive. Either one of two things will happen. Either one, you'll agree with us, and then the matter will arguably be remanded to district court. Or the alternative, if you don't agree with us, then it will likely resolve itself.
Okay, so that, you have a hearing date for that motion?
June 4th is the date that the clerk will.
Okay, Mr. Ziegler, any objection to proceeding further during that motion hearing on June 4th?
Ryan Ziegler on behalf of the people.
Okay, Mr. Smith, were you able to hear that?
Yes, I was, Your Honor.
Okay, do you have any questions about how we're going to proceed with your case?
No, Mr. Seeger explained it all to me very well yesterday. Thank you.
Okay, very good. Thank you. That's all for today then. And if you can ask the guard there to have put Miss Barney in the room. Thank you.
Thank you very much. Have a nice day.
I'll be right back. It looks like I can go for 5.
All right, ma'am, are you Karen Barney?
Yes, sir.
Okay, we're on the record in People versus Karen Barney, case number 244909. The record should reflect Ms. Barney's present today from Wexford County Jail by video. If I could have counsel put your appearances on.
Ryan Ziegler on behalf of the people, Your Honor.
Thomas Seeger, agreeing with it on behalf of Ms. Barney.
Mr. Seeger, how did we want to proceed with Ms. Barney's case today?
Your Honor, it's currently my understanding that Ms. Barney is going to plea as charged. And the plea was somewhat built into the charge itself. But be that as it may, Your Honor, additionally, Your Honor, it's my understanding that people don't have any particular objection to boot camp to the extent that the court sends her to prison, which hopefully you don't do, but if you do like to do, I think they would not strenuously object.
Okay, and what is the current chart? The clerk's grabbing the files.
Possession of methamphetamine, Your Honor.
The tenure.
Yes, sir.
Okay. Mr. Ziegler?
Your Honor, just to clarify, it would be our position that we would not object to boot camp if she's otherwise eligible.
Okay. All right, Ms. Barney, were you able to hear all of that?
I did, sir.
Did you want to proceed with entering a plea today?
Yes, sir.
Okay, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Thank you. You can lower your hand. Ms. Barney, are you on any kind of probation or parole at this time?
No, sir.
Mr. Seeger, are you aware of any potential consecutive sentencing sanctions?
Your Honor, arguably, it may run consecutive, and in fact, it appears to be managed primarily because it happened within the jail.
Okay, so she was under a sentence when the possession occurred.
But not only was she under a sentence, Your Honor, but it also occurred in the jail.
Okay. Would you agree?
I would, Your Honor, she was taken down from this court in her last sentence, and methamphetamine was found while she was in jail.
Okay, so Ms. Barney, you understand because of the circumstances surrounding when and where the offense in this case took place, that the court may have to impose a consecutive sentence. In other words, that any sentence in this case would have to run back to back with your current sentence as opposed to together at the same time. Do you understand that?
I do, sir, and I do understand why that has to be that way. I was not in the right state of mind, and it was not out of arrogance. I walked into the jail with drugs on me.
Okay. And then the maximum possible penalty in this case is up to 10 years and or a $15,000 fine. Do you understand that?
I do, sir.
With all of those things in mind, what is your plea to that charge today?
I choose to plead guilty.
So right now you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
I do.
And you understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, sir.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to do that, you would have to ask the next higher court up, which is the Court of Appeals, to hear your case. They could say no, and then you wouldn't be able to go any further with that appeal. Do you understand that?
Yes.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we've said here on the record today?
No, sir.
Is it your own free choice to plead guilty?
Yes, sir.
Are you pleading guilty because you are guilty?
Absolutely, yes.
The information I have shows that this happened on or about February 2nd of 2020, or I'm sorry, February 6th of 2024. Is that the correct date?
No.
On that date, were you present here in Kalkaska County?
Yes, sir.
And while you were present here in Kalkaska, did you have possession of some methamphetamine?
Yes, sir.
And did you know that that's what that substance was?
Yes.
Did you have any legal right to have it at that time?
No.
All right, thank you, Mr. Ziegler. Are the people satisfied with the factual basis?
Yes, sir.
Mr. Seeger?
Yes, sir.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Seeger?
Yes, sir.
And Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Seeger?
Yes, sir.
Ms. Barney, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. You do have the right to have that hearing. Actually, she's being held on behalf of Kalkaska, so she'll be right here.
Yes.
Okay. So Ms. Barney, you'll have a chance to review the pre-sentence report and speak with Mr. Seeger prior to the sentencing hearing. Do you have any questions about how we're going to proceed?
No, sir.
Mr. Seeger, anything further on this file today?
No, Your Honor.
Mr. Ziegler?
No, Your Honor.
Thank you, Ms. Barney. That's all for today, and the court is going to disconnect at this time. Mr. Travis, were you ready? Mr. Morrison's case?
Yes, Your Honor.
Okay. People versus Stephen Morrison, case number 2487. Record should reflect Mr. Morrison present here in the courtroom today. If I could have counsel put your appearances on.
Brian Ziegler on behalf of the people, Your Honor.
Kyle Travis on behalf of Mr. Morrison.
This is the date and time set for sentencing in this matter. Mr. Morrison, have you had a chance to go through the pre-sentence report and talk to Mr. Travis about that?
Yes.
Mr. Travis, are there any additions, deletions, or corrections?
I don't believe so, Your Honor.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
Your Honor, on page 2, the Department of Corrections recommendation, subparagraph 2, you must pay restitution in the amount of $1,000 as follows, full amount to Randall Nash. If the court reads through the victim impact statement, that $1,000 is a deductible that is payable to Forefront. So the restitution should be paid forward to Forefront Credit Union as described in the victim impact statement.
Okay, thank you. Any objection to that correction?
No objection, Your Honor.
Any other corrections, Mr. Ziegler?
No, Your Honor.
Do you have any victims that wish to address the court today?
No, Your Honor.
Anything on behalf of the people for allocation?
Your Honor, this is a case where the defendant tried to cash fraudulent checks across multiple counties. My understanding is that he's already been either pled or sentenced in other counties for this behavior. He does not have a lengthy criminal history. However, I think it's important for this county to send the message that this kind of behavior is not acceptable. We've had a number of these kinds of cases in the preceding months. It's becoming somewhat common. And so I think the recommendation of a local term of incarceration, even though this is a misdemeanor, is an appropriate sanction, especially considering the fact that he's already been punished in other counties for this conduct. I think it's important that we give him something over and above just fines and costs and telling him that he's on probation out of another county. So I don't see that an additional probationary sentence would do much good. He's already going to be on probation to another county. I don't see a need to duplicate that. I do think a term of local incarceration at the lower end would be appropriate to send a message both to him and to the community that this is a crime and that it's not going to be tolerated by this county. Thank you.
All right, thank you, Mr. Travis.
Thank you, Your Honor. Your Honor, Mr. Ziegler's right. I have seen a number of these cases, but what I would point to the court is this is not Mr. Morrison's plan, and generally these folks, it's not their plan. Mr. Morrison was very down on his luck, basically homeless in the throes of being an alcoholic, and organized crime, as near as I can tell, finds these folks, particularly down in the Grand Rapids, Muskegon area. They grab them up. They often buy them shirts and clothes. In my opinion, not to sound racial, they usually pick white guys because I think it works a little better. And they drive them around up here. They hand them checks and they shove them out the van into a local bank. And Mr. Morrison's not the first person I've represented in this situation. They then take far and away the vast majority of the money received. Usually very nominal dollar figures are given to the folks who are actually passing the checks, and they set it up. You know, it is noted was a cooperation agreement in Wexford. He said everything he knew. I've had other people where they do that. They set it up so they don't know who these people are, so they can't really say much. I mean, the best we usually get is, well, maybe I was taken to this apartment, or maybe I went from this car to that car, or I met this other person. I say this largely to point out to Your Honor, I get that this is a problem, but intelligent criminals plot this out and take advantage of people who are weak and in a bad spot to do this. It is not that Mr. Morrison or the other individuals I've represented who've been brought into this situation are sitting there thinking, I'm going to pass some bad checks today. They're sitting there thinking, I need to get a fix. I'm hungry. I don't have anywhere to sleep. And somebody comes along and says, hey, you want to make $150? Come with me, get in this van. And Mr. Morrison comes before the court in a far better position than he was back in 2022. He's got a handle on his drinking, he's employed, he's made substantial progress on paying the restitution in the other 2 files. He's got this file and another one that he's waiting sentencing on. And he's gonna make good on this restitution. We were discussing that. Our request to the court, and I would also note that this all kind of came about at the same time. Granted, he legally only has 3 days of credit, but if we look, I think he's got 43 days of credit in the Antrim case, 35 days of credit in the Wexford case. This was all the charges were out there at the same time. This is basically a function of when he got arraigned. So it's not as though he didn't spend any time in jail. He spent almost 2 months in jail during the course of this. So there has been punishment. So I understand that there's really not a need for double probation, but the one thing that is still out there is fines and cost and restitution. Mr. Morrison's employed and is, as I stated, making good progress on his other restitutions. So we would ask the court to consider maybe just placing him on a year of probation, not because he's not being monitored somewhere else, and I understand the argument that those are duplicative, but to basically make sure he pays this money back, and if he doesn't, then put him in jail. Because he is doing for himself and for society what needs to happen. He's working and he's paying his restitution. So I would ask the court to consider, instead of incarcerating him, putting him on probation to make sure he pays this restitution. And if he doesn't pay the restitution, at that point, then the court would be left to its choices. Thank you, Your Honor.
All right, thank you. Mr. Morrison, anything that you wanted to say?
No, not really. My attorney pretty much said it perfectly.
All right, I did read through the report. I'm familiar with the circumstances in this case, as well as your background and your history, Mr. Morrison. And taking all those things into consideration, number one, I don't think probation in this case is appropriate or will be productive over and above what's happening in other jurisdictions. So the real question is, what should the penalty be in this case? And I can fully accept what Mr. Travis is saying about, people who are in bad condition, whether because of substance abuse, because of poverty, whatever it may be, are certainly more susceptible to engaging in this kind of conduct. And that's unfortunate. And I can see where people get to a point where they're desperate and they'll do whatever they need to do to survive. But it's still a choice that you make, and you chose to engage in criminal conduct here. And I have no doubt, based on the report, that you knew exactly what was going on. And they're financial crimes that have actual victims. People are victimized by this type of thing. And I'm sure law enforcement and certainly the justice system would love to get a hold of the people who are orchestrating this. But the court also has an interest in discouraging the people who are carrying it out from doing that. If the bigger players can't find people to go in and cash these checks, then it puts them out of business too. So the court has an interest in deterring this kind of conduct and punishing it. And given what sentences you received in the other cases, and recognizing the fact that the court could sentence you to up to a year in jail, the court finds that an appropriate sanction here is 90 days in the Kalkaska County Jail. It'll serve as a punishment for you for engaging in what you knew was wrongful conduct. Hopefully it'll serve as a deterrent, so that if people are faced with a choice of, do I want to engage in something that's criminal, or do I want to try and find another way to support myself, they're not going to choose the criminal route, because they know that there's going to be a sanction involved in it. So the court is going to sentence you to 90 days in the Kalkaska County Jail. You do have credit for 3 days served. The court is going to order that you pay restitution in the amount of $1,000 that's payable to the Kalkaska County clerk to be dispersed to Forefront Credit Union, a crime victim's assessment of $130, attorney fees of $350, court costs of $325, and a state cost of $53. You do have the ability to seek an appeal of this sentence. Because it is a misdemeanor, there are no written appellate rights, but if you wanted to appeal this sentence, then you would need to file that within the next 21 days. If you have more questions about that, I'm sure that Mr. Travis can help you with that. Mr. Ziegler, anything else that we need to address for the record today?
No, Your Honor.
Mr. Travis?
No, Your Honor.
And Mr. Morrison, you are remanded to the custody of the county at this time. All right, our next hearing is at 10:15.
He is out in the lobby, so okay, he is. Thank you.
All right, Mr. Ross, if you can hear me, you need to connect your audio. There we go. Mr. Ross, are you able to hear me okay?
Yeah, there we go.
Okay.
Sorry about that.
No, that's okay. Mr. Ziegler, you're not handling this matter, right?
Correct. It's the Attorney General, Your Honor. I was gonna step out and make the call.
Oh. Wait for the AG's office to sign on. All right, Ms. McCree, are you handling this case on behalf of the Attorney General's office?
No, Your Honor, I'm observing. This is my first week as a SAG, so I'm supposed to be observing Ms. Brenner. It's my understanding that she'd be logging in. I can text
Okay.
her.
Yeah, that'd be great. Thank you. While we're waiting, do you have anybody else that we can take there, please?
Yes, I believe Mr. Starky is,
Mr. Starky? Okay. All right, we're on, Mr. Ross, if you can just wait on the line, we're waiting for, the lawyer for the state, okay? Oh, well, Mr.
Yes, sir.
She just popped in.
Okay.
Mr. Starky, if you want, you can just have a seat there. All right, Ms. Brenner, are you able to hear me okay?
Yes, Judge. Sorry for my delay this morning. I was finishing up a plea in another court.
No problem. We're on the record now in People versus Aaron Ross. This is case number 244882. The record should reflect Mr. Ross is appearing today by video by prior approval of the court. We have Ms. Brenner on behalf of the state present by video, and Mr. Travis is present here in the courtroom today. I believe based on prior hearings, are we prepared to move forward today, Mr. Travis?
Your Honor, our defense's request would be for an additional adjournment. Mr. Ross last time asked for time to basically investigate what had happened in Montana. He's made some progress with that, but is not completed it. And actually, probably more what I would need time to talk to him about is now that there is potentially some issue with what happened in Montana. I did a bit of research, and I'm sure Ms. Brenner would probably tell me the same. This is a strict liability crime, and I'd like a little more time to talk to Mr. Ross about that, and to potentially get some documentation from him and exchange that with Ms. Brenner. The AG did file a discovery request, and I would discuss that with her either way. If that would change their opinion or not, I'm not necessarily optimistic about that, but it is a strict liability crime, is a little bit tough to swallow. And really, Mr. Ross and I just discussed that yesterday, that yes, you may have found some things, but arguably that doesn't matter. Which is a hard pill to
But what is it that we're researching in Montana that we think happened?
So there's two issues in Montana. One is what the state of Montana did with funds that they were given, and where they assigned them. It appears as though potentially there was overpayments on his other child support case. And the other is, it's Mr. Ross's belief, and I think he's struggling far more greatly to get any proof of this, that his employer was taking substantially more money from him than was actually going even to the state of Montana. And that's a civil issue he's got to deal with, and I think he's pursuing trying to get someone to help him with that. But so that was when the issues with the state of Montana kind of came out. It's like, oh, well, let me look at that, and as I'm sure you know, Ms. Brenner, like it really works, even though it seems like it should.
That may be, I have that situation in another county with another case where there were withholdings that didn't make it to the front of the court. And I think it may be a criminal matter. So he may want to talk to his local prosecutor, because if his employer took money and basically embezzled it from him and didn't send it where they were supposed to do, maybe he could get help from the local authorities there. So, you know, in the meantime, I would like to see him making some payment efforts towards the balance. I don't think that he paid $17,000, but we did get that bond money. I don't see anything else coming through, but I don't have an objection for us to further look into this, but that would be my only request.
And Mr. Ross can clarify, but we were talking about that, and that's another thing he wants to get going. I think he sent a direct payment of a check to Lansing yesterday, which obviously that hasn't shown up yet, but we are aware that needs to happen, and he is getting that going. There was a bit of financial difficulty after basically taking all the money the family had to make the bond payment, but they're back on track a bit. And I believe, is that correct, Mr. Ross? You mailed out a payment yesterday?
Yes, sir. I sent it to Lansing, and we just addressed it as Michigan child support.
Okay.
Oh, I think that's payable too. That was the question.
Yeah.
Oh, okay. Do you know how much did you send?
300 yesterday. I just want to make sure that it's going to get there, and then from then on, then we'll start sending as much as we can whenever I can.
Okay. So Your Honor, I don't know if you want to set it out for another pre-trial or how you want to work it on your docket, but I do not have an objection to continuing to look into those issues so the defendant can, talk to his local authorities if there is some sort of criminal issue going on that end with his past employer.
I appreciate it.
I'll leave it to the court's discretion.
All right, well, I guess here's where I'm at with it. This case was bound over in January, so it's 5 months old now. Unless the parties can agree on some kind of dismissal without prejudice, so the AG can bring this again later. I'm not in a position to put this case on hold until Mr. Ross files either a civil suit or a criminal action in Montana, runs the course of that, gets restitution, and then is ready to adjust this. I mean, I'm just not, and the court's not in a position to have this case on hold. So
and
we're gonna
we
need to
have
go.
discussed, I'm sorry, Judge, to interrupt, but we have discussed a delay of sentence option. If the court would entertain that type of agreement, that would be a way that we could delay it and the defendant could still potentially get a reduction of the charge, and that would get him a year's time to, figure things out on his end if the court does that type of agreement.
Yeah, I have no objection to that. And I don't have an objection to giving you guys another month to work on something like that as a resolution. But I'm not going to just leave this file open until, what may or may not happen eventually in Montana does or doesn't happen. So.
Okay.
I didn't anticipate, and that wasn't really the request, at least from.
I didn't know where we were going with it.
I understand it's kind of open-ended and it's not clear, and that's where I guess I would, and I think Mr. Ross would ask for just another 30 days and understanding that we can, I think likely, it's obviously up to Mr. Ross, would enter into a delay agreement. So and it's his intention in our discussions that he understands the money's got to get paid. Whether it was stolen from him or not, it's got to get paid, and he understands that.
Yes.
I think this is, I'd like a little more time to let Mr. Ross kind of get a handle on this, but two, to discuss kind of the merits, because we kind of just had this conversation yesterday. Look, Mr. Ross, I don't know that this is a defense. And that was kind of that's a hard pill to swallow.
Mm-hmm. Okay. All right, so we'll set this for another status conference in 30 days, and the parties need to come to court with some kind of resolution at that time. Whatever that may be. And, I'm open to delay of sentence, probation, those types of things, maybe even a conditional plea, something like that. There's lots of mechanisms in the court rule. And I think all of our goal here is to get this child support taken care of one way or the other. And so I'm open to getting creative in ways to do that other than just leaving this file out there. So.
Thank you.
With that being said, I'm going to ask counsel to go to work on that over the next 30 days and come back with the resolution. So that's all for this file today. Thank you. All parties are free to disconnect at this time.
Okay. So Your Honor, the court will just send us the new date then?
Correct. Yep.
Okay. Thank you.
Okay. Thanks.
Thank you.
Okay. Mr. Starky, if you can come up to the podium, please. We're on the record in People versus Starky, case number 244901. I can have counsel put here.
I'll Travis on behalf of Mr. Starky.
Mr. Travis, how did we want to proceed in this file?
Your Honor, it's my understanding the prosecutor would offer that if Mr. Starky pled to count 1 under 7411 deferral and an added, I guess maybe count 4 of operating while impaired, they would dismiss count 2 and count 3.
So the 93-day misdemeanor impaired.
Correct, Your Honor.
Is that the correct offer, Mr. Ziegler?
That's correct, Your Honor. Count 1 under 7411 and count 4 impaired.
All right, Mr. Starky, have you had a chance to speak with Mr. Travis about this agreement?
Yes, I have.
Is that how you want to proceed today?
Yes.
Raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
I do.
Thank you. You can lower your hand. Mr. Starky, are you currently on any kind of probation or parole?
No,
And have you ever been convicted of a controlled substance related offense in the past?
no,
You understand that by pleading guilty to count one, the maximum possible penalty for that charge is up to 4 years and or a $25,000 fine.
yes,
And you understand that by pleading guilty to this added count 4 of operating while impaired, the maximum penalty you could face would be up to 93 days in jail and or a $5,500 fine.
yes,
With all of those penalties in mind, what is your plea to each of those charges today?
guilty,
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want it. Do you understand all those rights?
I do,
You understand that you're giving up and waiving all of those rights by pleading guilty.
I do,
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you would have to ask the next higher court up, which is the Court of Appeals, to hear your case. If they said no, then you wouldn't be able to go any further with that appeal. Do you understand that?
I do,
Has anyone threatened you with anything to get you to plead guilty?
no,
Has anyone promised you anything other than what we said here in court today?
no,
Is it your own free choice to plead guilty?
yes,
Are you pleading guilty because you are guilty of each of these charges?
yes,
All right, so this happened back on February 21st of this year, is that correct?
yes,
On that date, were you present here in Kalkaska County?
yes,
Had you been operating a vehicle on US 131 here in Kalkaska County on that day?
yes,
Prior to that, operating that vehicle, had you consumed some drugs or other controlled substances?
yes,
And did the use of those substances affect your ability to normally and safely operate that vehicle at that time?
yes,
And were you in possession of some amount of heroin or fentanyl or cocaine?
yes.
Okay. What did you think that substance was? Or did you know what it was?
I just thought it was opiates.
Okay. Did you have any legal right to be in possession of that at that time?
No,
Counsel, you're both satisfied with the factual basis?
yes, Your Honor.
Yes, sir.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Travis?
No, Your Honor.
Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Yes, Your Honor.
Mr. Starky, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea as to both. We'll set this matter for a sentencing hearing. Before you leave court today, you're going to meet with Mr. Barrett from the probation department to set up a pre-sentence interview. And then you'll be notified of the date and time of that sentencing hearing. It's important that you stay in touch with Mr. Travis prior to that hearing, okay?
okay.
Mr. Ziegler, anything further on this file?
No, Your Honor.
Mr. Seeger, or Mr. Travis?
Oh, Your Honor, I'm sorry, there is a issue we wanted to ask about. Mr. Starky is doing urine tests, and I imagine when first on probation that might change, but he's getting quite busy with work. He was wondering if he could have permission to test in Traverse City.
Mr. Ziegler?
I don't have an objection as long as he's regularly providing those to the court, Your Honor.
Okay, so Mr. Travis, if you'll do a stipulation amending that condition upon the court will sign that.
Okay, thank you.
Cap code for that.
Yeah, 257.625 3-A is an arrow.
Great, thank you.
And Mr. Carley's hearing at 10:35 got moved because of his recent incarceration in Kent County. So our next hearing set for 10:45. We'll take a brief recess until that time. Mr. Fields, are you able to hear me okay?
Yes, sir, Your Honor.
All right, we're on the record in People versus Fields, case number 2348770. The record should reflect Mr. Fields is present today by video from Ingham County Jail. If I could have counsel put your appearances on.
Brian Ziegler, on behalf of the people, Your Honor.
Good morning, Your Honor. Michael Horowitz on behalf of Mr. Fields.
Okay, so Mr. Horowitz, and correct me if I'm wrong, but I believe at the last hearing, based on the court's statements regarding sentencing, Mr. Fields, I think, wanted some time to discuss with you how he wanted to proceed in terms of withdrawing the plea. Is that correct?
I'd say that's accurate, Judge. There was a Kylander agreement for a HIDA that Mr. Fields had hoped to take advantage of. Your Honor basically indicated that she would not accept that agreement or wouldn't go along with the Kylander because of Mr. Fields, I'd say a typically large juvenile record. And so with that, the discussion became whether or not Mr. Fields wanted to withdraw his plea or not. I had subsequent conversations and discussions with Mr. Ziegler. We reached a new agreement, which would be Mr. Fields would, I guess, reaffirm his plea that he's already issued or entered, and making sure that it's knowing and voluntary, and that we would agree, I guess, vis-a-vis Kylander, to follow the recommendations and the pre-sentence report, which is for a local period of incarceration.
Okay, so are the underlying charges changing or just the Kylander agreement's changing?
Just the agreement, Your Honor.
Okay.
And we figured, I threw in the language about reaffirming just to make sure that the incentive here for the parties is that we maintain the plea that was previously entered. We're just tweaking the agreement in a way that we hope the board finds proper.
All right, so just removing the HIDA part of it and limiting the maximum sentence to 12 months.
Yes, sir.
Okay. Mr. Ziegler.
Fair statement of the agreement, Your Honor.
All right, Mr. Fields, were you able to hear all of that?
Yes, sir, Your Honor.
Okay, and is that what you discussed with your attorney with Mr. Horowitz?
Say it again, Your Honor.
This new agreement regarding your sentence, that it be limited to a local sentence, which would be a maximum of 12 months. Is that what you've discussed with Mr. Horowitz?
Yeah, with time credited.
I'm sorry, say that again.
I said, yeah, and with time credited.
Right, you're entitled to whatever time you would be entitled to, yeah, for credit.
Okay. Okay, yes, sir, Your Honor.
But it would not include HIDA as part of the sentence. Do you understand that?
Yes, sir, Your Honor.
Okay. All right, can you raise your right hand, please, Mr. Fields? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, Your Honor.
Thank you. You can lower your hand. All right, so Mr. Fields, do you recall we went through a plea hearing where you admitted that you were guilty of the charges in this case under the plea agreement? Do you recall that?
Yes, sir, Your Honor.
Okay. And do you agree that as you sit here today that that was truthful testimony and that you wish to reaffirm that plea that you previously made?
Yes, sir, Your Honor.
Okay, and the only difference being that when we have this set for sentencing, as opposed to HIDA being part of your sentence agreement, that the agreement would be that you would not receive a sentence in excess of 12 months in the local jail with credit for time served.
Yes, sir, Your Honor.
Okay. All right, so the court finds that Mr. Fields has reaffirmed his prior plea and that he understands the change in the agreement here. I'm satisfied based on my previous review of the PSI, that, you know, at this point, the court is willing to agree to the sentence agreement. So, that won't be an issue at sentencing. I think we do need to have an updated report with the current jail credit, and any other changes that have occurred since the prior PSI was prepared, which I would anticipate it could be a whole lot. And then the court would put this on for sentencing at its next available date. Mr. Horowitz, do you have any objection to that process?
No, Your
Mr. Ziegler?
No, Your Honor.
Okay. All right, Mr. Fields, do you have any questions about how we're going to go forward then from here today?
No, sir, Your Honor.
Okay. All right, thank you. That's all for today then, and the court is going to disconnect at this time. Okay, people versus, who do you have, Mr. Travis? Is this Mr.? Do you have your client? Right?
Jerry Horg.
Is that how your name is pronounced, sir?
Horgs.
Horgs. Yes, sir. This is people versus Horgs, case number 244911. Record should reflect Mr. Horgs present here in the courtroom today. If I could have counsel put your appearances on.
Ryan Ziegler, to be clear.
Kyle Travis on behalf of Mr. Horowitz.
Thank you. Mr. Travis, how did we want to proceed in this?
Your Honor, largely the defense would be asking for an adjournment. Mr. Horowitz, I think actually. So I think he had went to Bear River a day or two before the preliminary exam. And had been in there until not last Sunday, but the Sunday before. Ms. Gomez emailed me, I'm not sure exactly, mid last week, asking about his whereabouts, trying to get in touch with him as there was a sobriety court referral made in this matter. It took me a minute to locate him. I think on Friday, I emailed her back with contact info for him. So we are hopeful to get him at least looked at for sobriety court, but that has not happened yet.
All right, Mr. Ziegler, do the people have any objection to adjournment to allow Mr. Horowitz an opportunity to see if he qualifies for sobriety court?
No objection, Your Honor.
Just looking at the charges here and the dates involved, I think it would be appropriate. Mr. Horowitz may be a good candidate for sobriety court, so 30 days going to be enough for that, Mr. Travis?
Ask Mr. Ziegler more than myself.
I would hope so, Your Honor. I know we have a meeting this afternoon.
Okay.
I don't know if we're going to come to a final decision at that meeting or not. I don't know how much opportunity Ms. Gomez has had to speak to Mr. Horowitz, but I'm hopeful that 30 days will be sufficient.
Okay, so Mr. Horgs, over the next 30 days, it's going to be really important that you stay in touch with Ms. Gomez and that you follow up with any requests that she has for information. And obviously continue to follow your bond conditions. And we'll set this matter for a hearing in 30 days. Also make sure you stay in touch with Mr. Travis, okay?
Yes, sir.
Mr. Ziegler, anything further on this file today?
No.
Mr. Travis?
Nothing further, thank you.
Okay, that's all for today. Thank you. Can you, Terry, can you check and see if there's a Mr. Curry or Mr. Armstrong out there? Mr. Horowitz, who have we got here?
This is Mr. Evans.
Okay.
I also have Mr. Glaro and Mr. Knoll.
Okay.
I don't know if we'll have Mr. Knoll though, Judge. He's in Traverse in custody.
Well, let's start with Mr. Evans' case and see where we go from there. The court calls people versus Anson Evans, case number 234811. Record should reflect Mr. Evans is present here in court today. If I could have counsel put your appearances on.
Ryan Ziegler, on behalf of the people, Your Honor.
And Michael Horowitz on behalf of Mr. Evans.
Thank you. Mr. Horowitz, can you tell me where things are at with this file?
Judge, this was a case where I got brought in for appellate purposes, which is, my primary occupation. Since that, I believe I have become the trial attorney, and Mr. Evans, 2 other trial counsel have exited the case. Mr. Seeger filed a substitution on my behalf, and I don't know what happened to the other gentleman. I believe out of Kylander, it's not Seeger. That said, I haven't completed the appellate side of things. I got held up between other cases that I'm working on in the appellate world, including 2 murders and a termination case that involve mountains and mountains of records and transcripts. I have his appeal. It's not an appeal, it's application for interlocutory. I have that done. It's fileable. I just need to go over it with them. I think if the Court of Appeals grants interlocutory appeal, we're looking at 4 to 6 months. If they deny it, we're looking at 1 month to 2 months. So I would ask for to adjourn for 2 months, understanding that the delay at this point is kind of just sitting on my shoulders.
Right. Mr. Ziegler?
Your Honor, under the circumstances, I wouldn't oppose a brief delay to allow that appeal to be filed.
Okay, so you haven't filed for leave for interlocutory yet, but you're in the process of that, is that?
Correct, Your Honor.
Okay. All right, so the court will set this for a status conference in 60 days.
Thank you.
And we'll see where we're at that point if the application's been filed. We'll see if we have a decision yet in the Court of Appeals, and we can go from there. Mr. Evans, do you have any questions about how this is going to play out in terms of, your counsel wants to file an interlocutory appeal, the Court of Appeals, they're going to make a decision, yes or no, whether they take it. If they take it, obviously, if this case can be pushed out until we have a decision. If they don't, then we'll decide how we're going to move forward here. Okay. All right. Mr. Horowitz, anything further today?
No, Judge, thank you.
No Curry, no Armstrong.
Okay, the court calls People versus Armstrong. This is case number 24400. This is set for hearing at 10:45. It's now 11 o'clock. I just asked the bailiff to check the hallway. Neither Mr. Armstrong or Mr. Curry are present. This was reset from by stipulation of the parties from April to today. And there is the correct date and time in the stipulation. So have you had any contact, Mr. Ziegler, with
Here under the last contact I would have had with Mr. Curry would have been arranging that stipulation to adjourn due to this conflict. I don't believe I've spoken to him in the meantime. I don't know why neither he nor his client would be present today.
All right, so the court will just note that both defense and defendant and defense counsel failed to appear. The court will set it for a status conference and show cause at the court's next available date. If they don't appear at that time, then we'll determine how to move forward from there. And can you check and see if there is a Housel out there?
1 minute ago, there was not.
Okay.
And neither was the attorney.
Okay. All right. The court will call People versus Sarah Housel, case number 234824. set for 11 o'clock. It's now past 11, it's 11:05. Or has an attorney of record, Mr. Mason. No one's here on behalf of the defendant, and the defendant is also not here. Looks like this has been moved out a number of times. Have you had any contact with Mr. Mason on this, Mr. Ziegler?
Your Honor, other than the numerous times that Mr. Mason has contacted our office seeking a stipulation to adjourn, I don't know that I've ever had any contact with Mr. Mason on this case.
All right, so Ms. Housel has, just looking at my records, has failed to appear. December. I don't know that she's appeared since then. It's been repeatedly checked out. So, Mr. Ziegler, the court's going to ask that the people prepare a bench warrant also for failing to appear today. And this was set as a show cause for her. Because her attorney isn't here, the court will also set a show cause for the court's next available date for Mr. Mason for why he didn't appear today. Anything further for the record on this file, Mr. Ziegler?
Your Honor, just that I would note, I don't disagree with how the court is handling it, but just for the record, the defense counsel also failed to appear back in December on that date.
Okay. All right, if Mr. Mason fails to appear for the next hearing, the court will determine how to proceed as the attorney.
Thank you, Your Honor.
I see Mr. Knowles. Okay, we're going to take a short recess. The court will come back on the record at 11:15. Run the record in People versus Glaro. We've got a number of different files set for hearing today. We have probation violation in file 214552, 224645, and then pending file 244885. Mr. Glaro is present here in the courtroom today. If I could have counsel put your appearances in.
Michael Horowitz on behalf of Mr. Glaro.
Mr. Horowitz, how did we want to proceed today?
I think Your Honor was short two cases. I think we had a total of 4. I don't know if they're all on today.
Okay, I'll take your word for it.
The most recent case, Your Honor, which should, I guess, be a 24 case number, was just recently bound over. There was a waiver. This would be the first hearing on it in this court. There's been a plea offer extended by the prosecution to resolve everything. We're still fairly new on the new case. I think the allegations underlying the offense are probably said to have occurred like a month or month and a half ago. We're not ready to proceed because of the newness of that case. We'd ask to set these over to the court's, I guess, jury status is next month, so that Mr. Glaro can have enough time to consider his options in this case.
All right, Mr. Glaro, have you talked to Mr. Horowitz about that?
Yes, sir.
Is that how you want to proceed today? Okay, Mr. Ziegler, did people have any objection?
No, Your Honor, it's quite an involved plea agreement resulting in all 4 of the files. No objection to some more time.
Okay, and Ms. Wagner, on behalf of probation, do you have any objection to putting off your files until till next month when we may have a resolution of everything?
I don't, Your Honor, but I would like the opportunity at some point to speak with Mr. Horowitz so we can come to a resolution on my end for the probation violation for an agreement on that.
Okay, Mr. Horowitz, any issue with that?
No.
Okay. All right, so the court will set all files, all of Mr. Glaro's files over till next month for potential global plea resolution.
And Your Honor, Mr. Glaro has asked me to address bond, and we discussed that in the back. We're going to put together a bond proposal, probably on paper, so that everybody can consider it, a little bit more fully than just off the cuff. But would it be possible to schedule a hearing in the meantime on bond?
Yeah, contact Jennifer. And how much time do you think we would need?
I don't assume much.
Half an hour or less?
Yes.
Okay, I'm sure that we can find some time to get that in. So.
Thank you.
Okay, Mr. Ziegler, anything further on this case?
No, Your Honor.
Okay, thank you. That's all for today then.
We could talk about it. All right.
Thank you.
Oh, yeah.
Yeah, so that's fine. All right, we'll call Mr. Knoll's case, 234798, People versus Jeremy Knoll. And we have the council present. I do see that Mr. Knoll is in Grand Traverse, but I don't know if we had or where we're at.
Your Honor, there was a writ prepared for today's date to Zoom, signed by Your Honor back in April. It's like
Okay, so we do have a writ.
there is a writ in my file, Your Honor, signed by Your Honor for the Grand Traverse jail to produce him on this date and time.
Okay, let's just take a short recess and I'll have my office contact Grant.
See if you get.
All right, sir, are you Jeremy Knoll?
No,
Oh, what's your name?
Alec Knoll. I told him it wasn't me.
Okay, do you have is there a corrections officer outside the door there?
Yeah, I'll go find him. Thank you.
Last is in like the oldest.
I'm glad that I asked.
They need Jeremy Knoll, and I'm not that person. I go to 4. Okay, go ahead.
So Ms. Siegel, we're just getting ready to get started with another matter that was delayed a little bit from 11:15. So if you could just remain on the line, we'll get to your matter just as quick as we can, okay?
Absolutely. Do you know if Mr. Hedrick was written to be here from MDOC?
We can check.
Thank you.
I don't see that he was, Your Honor.
Sounds like he was.
At least our office didn't prepare.
Yeah, that might be I probably should have ensured that he was here, either done it myself or ensured that someone else was going to. So maybe I had better just reschedule.
Okay, yeah, I think this is probably a motion that he would need to be present for, and I can confirm that he was not read it for today.
Okay, I'm sorry. That was an oversight. I should have made sure that happened. I will call the court and reschedule and make sure he's here next time.
Okay, very good. Thank you.
All right, thank you.
So just going on the record in People versus Hedrick, case number 224729, we just spoke with defense appellate counsel, Ms. Siegel. She failed to writ Mr. Hedrick for today's hearing, so we are going to adjourn that hearing. She's going to writ Mr. Hedrick and then reschedule with the court for a different date.
They look very similar. I would love to know. It's done it before. I don't think it's still doing it. I don't. Yeah. Yeah. You can. Sorry. Exercise his rights. And, oh, that. Oh, it's so much. Send you the body check or phone calls. Oh, yeah.
Well, do you think you're actually gonna go get Mr. Knoll or?
I'd say it's 50-50, yeah.
I'd give it less than that. I don't think they probably even know we're still.
Do you wanna see if your assistant can call him again? All right.
Hey, Jan. Grand Traverse just refused to law Mr. Knoll. There's an empty group on Zoom. Another guy named he gives them a call and ensure that they're making correct Mr. Knoll.
If you'd brought your putter.
Yeah.
You could have,
Silver lining.
instead of the obstacle
I have
course.
my clubs in the car.
Oh, do you?
Keep my fly rod, my waders, and my golf clubs in the car.
You had chest waders?
Hmm?
Chest waders? Usually do, well, you do the asabo. Any other streams?
Manistee. Close.
Is it right there at lunch?
You probably spend more time on the asabo than Judge Hunter does.
I don't think so. I don't think anybody spends more time than he does.
I mean, he's out there practicing.
Yeah.
No. Schedule. Okay, thank you. Bye. Your Honor, I just heard back from my office. Apparently Grant Travers had sent into Benzie